Hello, my name is Brian, and I'm one of the attorneys here at Fidelity Law. These days, many people are considering a Chapter 7 bankruptcy as an option to help them deal with their debt situation. The first step in a Chapter 7 bankruptcy is to determine whether the debtor is eligible to file a bankruptcy or not. This eligibility has several components. First, you may not have already filed a Chapter 7 bankruptcy in which you received a discharge of your debts within the 8 years prior to your current filing. In addition, you may not have filed another Chapter 7 bankruptcy in which you did not receive a discharge of your debts within the past 180 days. There are also certain restrictions on prior filings of Chapter 13 bankruptcies, which vary depending upon the percentage of debt that you repaid in the prior Chapter 13 bankruptcy. In addition, a person must demonstrate that they are eligible to file a Chapter 7 bankruptcy by passing what is called the means test. This test is essentially a test to determine whether your income meets the statutory requirements to allow you to file a bankruptcy. If your income is below the median family income for the state in which you live, then you automatically qualify. If your income is above the median family income, then you can still certainly qualify, but a more complicated calculation must be done involving both your income and your expenses. After meeting all of the eligibility requirements, the next step in a Chapter 7 bankruptcy proceeding is to take a state-approved credit counseling course. You need to take this course within the 180 days prior to the filing of the bankruptcy. There are certain limited exceptions to this requirement in emergency cases, but generally, everyone who wishes to file a bankruptcy must first take this course. It's pretty easy to complete, and you can usually get it done in about an hour, maybe an hour and a half. But it does contain really important information that's essential to anyone looking at bankruptcy as an option. The next step is to prepare the bankruptcy petition, along with all of the required schedules, which list out all of your creditors and assets, along with a whole series of additional information about you. Once these documents are completed and approved by the client, then we file these documents with the bankruptcy court, along with the required filing fee and the proof of completion of the financial counseling course that I mentioned a few moments ago. Once the petition is filed, the next step is that the bankruptcy court will review the petition and schedules to ensure that they're complete and that the client meets all the statutory requirements. If there are any deficiencies with the petition, then the case will likely be dismissed, unless the debtor cures those deficiencies in a timely manner. But assuming that there are no deficiencies with the filing, then the next step is that the bankruptcy court will set a creditor hearing date. This hearing is called a 341 creditor hearing, and it's held before the Chapter 7 bankruptcy trustee. This hearing gives your creditors the right to come and ask you questions about your assets or your debts. It also gives the trustee the opportunity to ask similar questions to allow the trustee to determine if there are any assets which they'll seek to seize and sell through the bankruptcy proceeding. After this creditor hearing, there's one additional counseling course that's required by the court, which again can be completed in about an hour. After that, the court will usually grant a discharge of all of your unsecured debts within the next 30 to 45 days after the creditor hearing. So the process of a Chapter 7 bankruptcy does have quite a few details and steps which must be done properly. But with careful guidance, it should be a relatively smooth process for you. Good luck and have a great day.